So this is video 2, weeks 11 to 12, chapter 8, performance and discharge. And my apologies, the first video went over the 15-minute time limit, and I didn't catch it. So there'll be some overlap to cover for that abrupt ending. He's all over the place, but in any event, we're trying to identify what is a breach of contract, because that gives rise to lawsuits and obliges us to consider, well, what are the remedies? What is a court going to do if we can establish that there's a breach of contract? And we can say this, and just bear with me, when the performance rendered by a party is less than either complete or substantial, then there's been a material breach of contract. What we can also do is shorten material breach of contract to simply breach of contract. So what I'm going to say, why did I put material breach of contract? Because that's the way, at least academically, scholarly, for those people unlike me who are scholars, that's the way they say it. But to be down and dirty, a breach of contract means that there's been performance that's been less than complete, but also less than substantial. Now, if there has been a material breach, or in our vocabulary, breach, the party who is not in breach is excused from their performance of contractual duties and has a claim to sue for damages resulting from the other party's breach. So we can say that a material breach of contract discharges future performance as well as gives rise to a breach of contract lawsuit. Word of caution, and I don't have this in the posting, when we look at one type of contract, which is the contract between landlord and tenant for occupation of real property, we've got to be careful, because there the law of real estate trumps, I just love to use that word, trumps the law of contracts to this extent. If you are a tenant, and I'm making a big deal out of this because some of us have been or are now tenants. If you're a tenant, so long as you occupy the property, you have an obligation to pay rent, regardless of your claims that the landlord is in breach of the lease because the landlord hasn't made necessary repairs, etc., etc. So don't take to heart the rule that breach by one party relieves the other party of continued performance if it's landlord and tenant, and it's the tenant who claims there's a breach. If you stay in possession, continue to live in your apartment, continue to go to the office, etc., you have an obligation to pay rent. And I've seen lawyers get, not in landlord and tenant residential, but commercial, make some blunders in that area. Okay, now we're still in the area of performance, but we're going to talk about something else, and that is the time for performance. And if there's no time stated for performance in a contract, then the rule is, well, it's got to be performed within a reasonable period of time, and that's going to depend upon the subject matter of the contract, etc. What happens, however, if there's a date stated for performance? In that case, the rule is, and it's a little bit, to me, counterintuitive. The rule is that the contract must be performed by that date or within a reasonable period of time after the date. So, this hypothetical, you're having a family gathering, maybe a reunion, and you're going to have it at your house, and you want a gazebo built on the property, and you want the gazebo built certainly before your event is going to take place. So you hire a builder, and in the contract you have language that says that this gazebo must be built by, and it's a date before the party. Well, what can happen is the builder has until that date or a reasonable period of time after that date, which may leave you very frustrated. So in those kinds of instances, if a party wants to impose an absolute duty that the contract must be performed no later than a certain date, the way that's achieved is by stating not only the date for completion, but adding, it's almost magical, because it's been used over the years so much, time is of the essence. Well, now you've got time is of the essence, and that certainly then imposes an absolute duty, and we could say is if the party doesn't complete by that date, there's a breach of contract. But what we're going to learn in the next chapter is maybe the damages aren't that much, and what you really want is the damn thing built on time. So if you forgive me to say practical matter, but this is very practical, to ensure performance by that date is to have a penalty clause, or if you will, a liquidated damages clause in the contract. So now your agreement would require the party to build the gazebo by a certain date, and if they go beyond that date for each day or each week, however you negotiate it, they pay a penalty. So much of the contract price will be deducted. And sometimes, I don't know if it's going to be the gazebo example, but in some contracts, that's exactly how you get people to do things or businesses to do things on time. And I'm just going to give you an example of that. Some time ago, but in the last 10 or 15 years, I think, the Grand Island Bridge, for those of you who travel north of the city, on the 190 the bridge was being painted. In the States, and I never looked at the contract, but I read descriptions of it, the state wanted the painters off of the bridge by, let's say, 7 o'clock every morning so that the bridges could be opened both ways. Don't forget, back then there was toll booths, etc. And so what the state did is they had a penalty clause that, and I don't know exactly how it was worded, but let's just say for every 15-minute interval after 7 o'clock every morning that there were still painters on the bridge, the painting contractor paid a penalty of X number of dollars taken from the contract price. Now you've got somebody motivated to do something on time. And more of liquidated damages, remedies for breach of contract. And I think that should be Chapter 9, not Chapter 8, but shoot me. Okay, so we've done discharge by condition, discharge by performance. We've talked about complete performance, substantial performance. If you don't have either, you've got a breach of contract. Then we also talked about time of performance. And now we can kind of breeze through a little bit our next two categories. We can have a discharge by agreement and a discharge by operation of law. Discharge by agreement can be a little bit confusing, but we don't need it to be confusing for where we're at right now in studying contract law. So let's just say this. Parties to a contract can agree to discharge. You can have a discharge by rescission, discharge by novation. You can have a substituted agreement. You can have accord and satisfaction. Those may be of real concerns to attorneys, and you want to spend some time with it in that capacity. But for our purposes, let's just say this. A and B are in a contract. They can discharge it by agreement. And the different ways of doing it, really it's up to the attorneys to orchestrate it the correct way based upon what's at issue, etc. Finally, we've got the last category of discharge, which is discharge by operation of law. And I know we talked about the operation of law when we talked about termination of an offer back when we were looking at offer and acceptance and agreement. And operation of law means there's legal rules out there that call for a certain consequence here. The consequence is discharge of the contract. The significant ones are statute of limitations, meaning there's a time to bring a lawsuit for breach of contract and it has elapsed. You're not going to have to perform that contract now if you're on the winning side of the statute of limitations. Not all contracts, so don't think you're going to do this with your contract to pay back your student loan, but some contract obligations can be discharged in bankruptcy, and then finally we can have impossibility or impracticability of performance. Yeah, you and I have a contract, you're going to buy my house, but after we enter into the contract, the house has burnt down. Well, that clearly makes it impossible to conclude the contract. Now I'm going to stop here, and what I'm going to do, I'm making a decision now. The material on breach of contract I'm going to push back until our next 2-week period, because I think we've done an awful lot just with performance and discharge. So this will conclude this video.